Hi, you guys. Good to see the early birds in here. ADev that Sudos. I don't know why I say studio. There's a global IT outage. Everyone who relies on Microsoft is sad. I use Linux, so I'm laughing. And a new motion to disqualify Hylton in love. Today couldn't possibly be any better. Hey, Becky. And then Hugh. So my job is the only one not having problems. I used to hate when stuff would go wrong, but my department was fine, and everybody else was like running around having a field day, having a snow day, had the day off. We're going to look at this motion. Surprisingly, it's only 3 pages long, really short from Brian Steele. And shout out to Justice Matters if they make it in here. They're the ones that said, hey, Brian Steele actually filed something at 5:32 p.m. last night. And then Joseph Papp just uploaded it. So really, really great to see all of the crowdsourcing and everyone coming together to keep updates together on this case. Hey to Red Bunny, hey to Paris, Knock, Kimberly, and Stuff, CBBJ. Hey Drea, everyone show Drea some love in the chat. And then Elaine, I like that name. And then Lovey, let's get started reading this. It's real quick. Make it a little bigger for you guys. And you can see there's a footnote in the title. So I don't know if Brian Steele's just making that his theme. But this is filed by Brian Steele. And it's a motion to disqualify lawyers, Love, and Hylton. Footnote 1 says this motion also applies to Judge Glanville as well. And he refers back to the supplement and the amended supplement to recuse Judge Glanville, filed like a couple weeks ago now, July 8th and July 9th. So again, we get this statement as always that Mr. Williams is innocent of all crimes in the above referenced indictment. As previously asserted, Lawyer Love and Lawyer Hylton have made themselves critical witnesses in this case, including, but not limited to, and this isn't going to just be dealing with Kenneth Copeland, when Lawyer Love engaged in text messages with witness Archelian Bennett. That's Miss Bennett. That is the witness who said she was afraid to come testify because the detective was hitting on her. So she had to appear her first day in court with cuffs on, because they were treating her like she was hostile or violating an order not to appear to give testimony, when really it was the detective, who's an actor on behalf of the state, who was harassing her. And back during that time period, it was Keith Adams that did the cross-examination of Miss Bennett, but Brian Steele raised some hell about Adrienne Love injecting herself as an unsworn witness, because the types of questioning that she was doing to get information from Miss Bennett, she was putting testimony in her questions, rather than letting the witness speak and deliver the testimony. So here we see that recalled, that whole situation recalled. So because of what Love did to engage in these text messages with Miss Bennett, and Lawyer Love, Lawyer Hylton, and Judge Glanville communicated with sworn witness Mr. Kenneth Copeland at a critical stage of Mr. Williams' trial during the now infamous June 10th, wholly improper ex parte in Chambers meeting. Undersigned counsel has the duty to cross-examine or examine Mr. Copeland, Lawyer Love, Lawyer Hylton, and Judge Glanville on all facts of the secret strategy session. And he's going to cite over here, pursuant to the Confrontation Clause, the right to present a defense, the 6th and 14th Amendments, right to effective assistance of counsel, due process, right to a fair trial, as well as a fair tribunal on behalf of Mr. Williams, under both the state constitution, Georgia Constitution, and the United States Constitution. Confrontation Clause, due process, those are all things that we all as citizens of the United States, we are guaranteed under the Bill of Rights. We are supposed to have those protections. So Brian Steele says this will mandate that Mr. Copeland be cross-examined before the jury about his meeting and conversations with Lawyer Love, Lawyer Hylton, and Judge Glanville. This essential questioning injects the veracity and credibility of Lawyers Love and Hylton and Judge Glanville. Undersigned counsel will also examine Love, Hylton, and Glanville as to why they knowingly made false and misleading assertions to Mr. Copeland about the alleged disloyalty of Mr. Copeland's lawyers and provided legally incorrect information to Mr. Copeland in order to persuade him to testify, based upon their own deliberate and intentional concealed misconduct. So deliberate, intentional, and concealed, all 3 of those words are misconduct in their own way. You did this knowingly. You did this purposefully. And then you tried to hide it. Judge Glanville's lawyer, Hylton's, and Lawyer Love's credibility and acts are now at the center in Mr. Williams' trial. These lawyers must be removed and disqualified from further participation in the case, save as witnesses. And then he cites, professional conduct rule 37A, and then also some cases. So LaValle v. State, Martin v. State, which we've seen a few times before, Stewart v. State, Schaff v. State. And then during the jury charge, it is expected that this honorable court will be asked to instruct. So we need a curative instruction. Instruct this to the jury because of all of the stuff that's happened. Suggested pattern jury instruction 1.70.10 as follows. The court has no interest in this case. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witness, upon the evidence, or upon the guilt or innocence of the defendant. Undersigned counsel requires this above testimony from lawyers Love and Hylton and Judge Glanville in order to have the deliberating jury consider whether Glanville was, in fact, biased for the prosecution, and that this jury instruction is not applicable prior to July 15th, 2024, the day that Mr. Williams' motion to recuse Judge Glanville was granted. So wherefore Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of the same, asks this honorable court to grant the above requested relief. So they want a hearing. They don't just want a decision. We want a hearing on this. And we're not going to hear this issue hashed out today. Guys, the defendants aren't going to be present at today's status hearing. What today is going to be good for is getting an idea of timeline. What future dates are coming up? What are we going to tell the jury in the meantime, possibly? We're not really going to hear many arguments or decisions being made, but we might hear that more things are filed today now that, because this was addressed to Whitaker. So now that we know what judge we're writing to, you might see some other motions come through today, maybe Monday. But yeah, so that was that. That was a really, really, really short one. But it brought up that Miss Bennett story, which was really big when it happened. I thought it was really short, clean, concise. And then just so I get that in there, Keith Adams is a signatory on it. It's not just Brian Steele. Oh no! Frosty, feel better. That sucks. I definitely think it's going around. And Justice Matters is the one that said, hey, this slipped through last night at 5:32. So shout out to Justice Matters for guys, look, there's a motion. And then what are you guys thinking? I know you guys have some thoughts on the Miss Bennett situation. Hey Aisha, good to see you. Hey Matt. Hey Dewana. Hey Tammy. Hey Queen Brielle. Hey Redshot. Hey Kiana. Hey Tom. Hey Butta. And then I know you guys, who watched it live when Miss Bennett was on the stand? Because one of the things I really liked about Keith Adams is up until that point, he'd been really sharp with his cross-examination. Getting things out of witnesses, contradicting them. But when it was Miss Bennett, I think he very skillfully and strategically was very kind and understanding and gave her a chance to speak. And she was finally able to say, I didn't want to testify, I was uncomfortable. And I actually, if you guys want to tune into that, I do have it pulled up. It's about 8 minutes, his cross-examination of Miss Bennett. At least dealing with the part of why she didn't want to come to court. Yeah, Red Bunny. So Love lied to the judge, saying that she called him an a-hole just to get that warrant. Yep. Hey, for always and forever. I always want to switch your name in a different order, too. Oh, and Dixie Doodles, this is going to go on. I mean, we're probably going to hit, I feel like we'll hit a day 200 if this case keeps going. Plain Mary Jane confrontation clause means something so different to Brian YSL Steele, running up to that podium and say, I have an inquiry. So for today's status hearing, it's supposed to be 11:30 a.m. Eastern, so about an hour and a half from now, an hour and 35 minutes. Although we are seeing 11, so maybe I've got it wrong. I do believe you'll probably see a court feed from Law and Crime start at 11. They said that they're going to be in there streaming. They'll start the screen and it'll just sit on the wall until something happens in the court. And then, yeah, so I think it's interesting that we're going to get this hearing too, because we're going to see these motions argued orally, and they'll probably be expanded upon. And when there's oral arguments, sometimes you have to be very well prepared and know the case law that you're trying to cite. You can't just rely on a citation that you grabbed and not really understand what the case is about. You've got to be able to argue the interpretation of the case law that you're citing on the floor. And I think Steele is much stronger at that than Lawyer Love. I'd honestly say the same in writing too, but, you know. And then, so you guys are having your conversation, so sometimes I won't always know everything that's going on. Erica Dixon, good to see you. Who says free Fetty Wap? I forgot about him. He's not involved with anything YSL though, is he? Honestly, I feel like Fulton County would try to say that he is. You know what I mean? Like, they're just going to be like, it's all connected. It's one big scheme. Yeah, exactly, plain Mary Jane. So when the state tried to use one of Steele's cases against him, like, he's like, that was my case. So hey, all you guys that are coming in, we already did the reading. It was super short. Essentially, it's recalling what Miss Love did, the type of injected testimony she gave with her own questioning of witness Bennett. And then also now how they all met in this ex parte meeting and spoke with sworn-in witness Kenneth Copeland. And because of that conduct, that deliberate and that intentional conduct, that purposeful conduct, and the conduct that they tried to conceal after the fact, they need to be removed and disqualified from this case. So I don't think this is the first motion we're going to see. We'll probably see more filed today after this, the status hearing. I think they'll mostly say the same things, but I kind of want to see how the different attorneys say them. We have gotten to know Doug Weinstein's writing pretty well. We know Brian Steele's writing really well at this point. We got to see a little bit from Keratin Matthews yesterday, and I don't know, I've seen some arguments from him earlier, but there's still some other attorneys we haven't really seen address what they think about this ex parte meeting and writing. So that'll be really interesting to see if they end up filing their own. We see some different voices. DeWanna Miller, I think Doug Weinstein is waiting for a certain judge, like to know for sure that Whitaker is going to be the one staying on the case. I believe that Doug Weinstein 2 days ago already had the motion for bond and possibly a motion for mistrial already written up. But he probably was waiting to file them until he knew what judge it was going to be addressed to. And then, yes, you guys are remembering Miss Bennett's testimony. We can watch it, you guys, if you want to watch Keith Adams. I mean, honestly, Love's questioning of it was kind of the fiery in a bad way, I would say, part. But Keith Adams is where we get out why Miss Bennett was uncomfortable. And Love, Lawyer Love, nothing new to you guys, but even if you missed that day, you can probably picture it. Love was rolling her eyes. She was all like annoyed that witness isn't telling me what I want to hear. So let me switch over to this. And it'll be nice. We'll get some Keith Adams. For anyone who hasn't really followed the trial for a long time, you'll get to see a bit of Keith Adams.
When you testified yesterday,
there we go.
You were on edge. Is that fair to say?
Yes.
You didn't want to be here.
Yes.
And part of it is because of the interactions, and your reaction yesterday was based on the interactions you had, not with Mr. Williams or anyone over here, but with the district attorney's office. Isn't that true?
Yes.
You told us when you were back there that they had been, quote, harassing you for a number of months. Is that true?
Yes.
And in fact, you said that prior to coming out and testifying, that the only person you were afraid of, you didn't want to be around, was Investigator Hamilton from the district attorney's office. Is that true?
Yes.
And you're saying that to us, and then your testimony subsequent to that was based on the interactions that you had with Mr. Hamilton. Isn't that right?
Objection, Your Honor, paid as to the question.
I sustain the objection. You can...
Okay.
Space when they got it sustained.
Mr. Hamilton had contacted you prior to yesterday. Is that right?
Yes.
He would call you from time to time. True?
Objection vague.
What is, can I have some,
I'll rule the objection. You can answer.
Yes.
let me just ask you the questions, okay? Mr. Hamilton had harassed you, is that correct?
Yes.
In fact, you told us when you were back there that you didn't want to come out and see him because he had sexually harassed you. True?
Yes.
You felt like, and you told us, that you were really concerned about coming out here.
I'm going to object
Cases.
as to relevance.
I'm gonna rule the objection.
You told us that the times when he would contact you, it seemed like he was trying to date you.
Yes.
Let me ask you guys, because the objections that Love is lodging here, vague, oh, that one was sustained. Relevance, oh, I'll overrule that one. And I'm not really sure if I think Judge Glanville gives that much thought to what he's overruling or sustaining here. It just seems like sometimes he just gives and then doesn't give to make it seem like he's being fair to both sides. But would you guys say that this type of situation isn't relevant testimony? That if a detective working this case, looking at this case, was making a witness feel uncomfortable, is that not relevant? Is that not something that the defense attorney should be able to ask the witness about? That's true.
In your interaction with, and Mr. Hamilton, you actually met with him at different locations. Is that right?
Yes. I met him at a restaurant.
Japanese restaurant off of Moreland Avenue,
Yes.
a couple months.
Japanese restaurants sound like the type of place you go on a date. Or for a birthday or a special event.
Ago.
Maybe, I think February.
Okay. He wanted to meet you, supposedly to talk about the case,
Yes.
but he wanted to meet you by yourself.
Yes.
You did not feel comfortable with the interactions you've been having with the district attorney's office, and so you brought your 20-year-old son along with you.
Yes.
Same question as the form. You can-
So, Your Honor, if you could just have him break it up so we'll know what she's answering.
All right.
All right,
I
I'll break it up. You didn't feel comfortable going to meet him by yourself.
Nope.
Because you didn't feel comfortable going to meet him by yourself, you brought your 20-year-old son with you.
Yes.
Was that before or after you met with Mr. Hamilton and he told you, don't talk to nobody else?
That was after. He told me before that. I came in, I seen Miss Love, and that's when I told y'all yesterday that me and Miss Love, we only discussed for a brief because they was like trying to tip me. And that's when I went to talk to him and a couple of more people from their team that I don't see right now. And then he ended up getting me by himself and asking me to give him my number and that he's gonna contact me and that I ain't need to speak with no one else. And if they contact me, do not answer or speak to them. Only him.
Okay.
So just for people joining now, hey Kat Madison, by the way, we are watching Witness Bennett. Miss Bennett was hit on by a detective and she was uncomfortable. She didn't want to come and testify. And the state, they brought her to testify in cuffs. And they tried to say that she was just being a flaky witness. And the state got so pissed off about it. But then you get Keith Adams up on cross-examination and we find out that the reason she didn't want to come testify was because she was uncomfortable. She was scared because the detective was hitting on her, trying to have her meet him at Japanese restaurants alone. Don't talk to anybody else. Give me your number. Oh, she expressed, hey, I can't keep meeting you all the time because I'm going to lose my job. Oh, I'll help you guys find work. Like, just weird stuff. And Love tried to call her flaky. Like, it said that was the whole issue. And guys, if you think the state's objections are annoying and stupid, hit the like button on this video.
He told you that he would like to take you out when this was all over, didn't he?
Yes.
And then he's, as far as you know, he is an investigator, law enforcement investigator for the DA's office, right?
Yes.
You didn't have a problem discussing with the district attorney's office this supposed incident from back in 2013, right?
No, I never had a problem.
Right. And in fact, when going back to you being asked yesterday about whether you were scared or anything like that, when you met with the DA's office, you met with them so often that you actually lost your job, didn't you?
Yes.
They would contact you and say, hey, you got to come talk to us. And because of the number of times that you had to just kind of drop everything, leave your job, and come talk to them, you lost your job, didn't you?
Hold on.
Yes.
I sustain objections to form. You can rephrase, Mr. Adams.
You lost your job because of having to go meet with them, right?
Yes, but they wasn't meeting with me every time they tell me to, though.
Subsequent to or after you lost your job,
Yes.
Mr. Hamilton, the investigator, told you, don't worry about that. Take care of getting you another job, all right?
Yes.
When you met with them, when you met with, I don't know, there was actually a time where you came here to the courthouse to meet with either an investigator or someone else from the DA's office, true?
Yes.
Okay. Were you supposed to meet with Miss Love? Were you supposed to meet with Miss Love?
Yes.
And you were brought here by an investigator, Investigator Long, right?
Yes.
You ended up not speaking to Miss Love that day, am I correct?
It's just for like a brief.
Okay.
Your Honor, I would object and ask that the witness answer the question, yes or no. I didn't understand the answer.
I'm gonna overrule the objection. She's answered the question.
When you, just to be clear, when you said a little while ago that Miss Love tried to tip you, is that what you said?
Yes.
What did you mean by that?
Because when I met with Miss Love at the Wendy's that she discussed, it was some things that we had talked about, and she told me like it was some things we talked about that wasn't gonna be brought up, but she wouldn't bring it up to me again, or we wouldn't have to discuss it.
Okay. All right. In your conversations, either with investigator or DA, they were asking you questions about 2013, correct?
Yes.
And you were asked yesterday whether you recall this supposed incident from back in 2013. Remember that?
Yes.
Your answer yesterday was you really didn't remember, right?
Yes.
Not talking about yesterday now, but going back a couple of months, or whenever it was you met with them, you told them then, and them being the district attorney's office, whether it's an investigator or a DA, you told them then, I really don't have a lot of memory or remember much about 2013, all right?
Yes.
All right, so if you guys want, we can pull up and... Ooh, is this a cross? Did it take us right to cross? Oh, okay, so this is where she's actually flaky. So it's auto-playing. So the situation was, Love essentially wanted to have this witness pin everything on Jeffrey Williams. He's part of this. And when push comes to shove, the witness isn't saying what Love wants her to say. This looks like it's 11 minutes long. It's cut off on my screen. But we can watch this, and you guys can hear the way that Adrienne Love speaks to the same witness that we just watched Keith Adams cross-examine. So, by the way, shout out to everyone new that was just jumping in. I saw Coco's here, Jason's here, Transplanted Texan, I think I saw you earlier and didn't say hi. And then I also want to thank Chrissy. Thanks for sending in the super chat. I appreciate you too. And yeah, you're going to see a stark difference between the way the defense questions and Love is questioning the same witness. And thanks for becoming a member, Heart of Inspiration.
Is it fair to say you never said anyone kicked your door down?
Have anyone ever kicked my door down?
I'm asking a different question. I apologize if it's not clear. Is it fair to say that you never reported that thug kicked in your door on Mother's Day?
No, I never reported he kicked in my door. You said I reported that I opened my door. I can't open it in, he kick it. And it don't make sense.
And that's why I said, is it fair to
Yeah.
say that you never reported that he kicked in your door?
No.
And is it fair to say that you never reported that you were shot on May 12, 2013?
I've never been shot. Unless y'all know something I don't know, because I ain't never been shot.
Thank you, Heart of Inspiration. You guys say thank you in the chat.
Thank you for being patient with us. If you give me just a moment, I'll have a few more questions, okay?
Yeah.
Now, Ms. Bennett, when you met this outside in the hallway, when you met with me outside in the hallway of this courthouse, were there investigators and other people around?
Mm-hmm.
And at that time, earlier this year, did you indicate you did not wish to speak with me anymore?
No. Somebody told me I ain't had to speak with you no more.
And who was it that told you that?
Mr. Hamilton.
It was your own people, Love.
Tell me that I made you uncomfortable.
No, I ain't tell you that. Because I ain't speak with you.
Say that again.
I said I didn't speak with you, so I couldn't tell you that.
You're saying now that you did not speak with me outside in the hallway?
I'm sorry, can I have Ms. Love please speak into the microphone? Or speak up?
I'll speak up, Judge.
All right.
Are you saying to the jury that you did not speak with me in the hallway?
No, you asked me, did I speak with you? Was it other people around? I said yes. Then you said, did somebody ask you to not speak with you? I told you yes on that. Then you asked me, did I tell you? And I'm like, how am I tell you if I didn't speak with you?
Ms. Bennett, did you express at any point that I made you want to cause yourself harm?
No, it was more not, really not you, but the people in your circle, your team, or whatever they call. Because, like, yeah, I was really, like, trying to, I don't know, manipulate, if that's the word y'all was trying to do, or something.
What was it that I tried to manipulate?
Like the situation.
How did I try to manipulate the situation?
I don't know, like, I felt like you kept trying to, like, confuse me. Like, you trying to do the same thing. Now you asked me, did I have a iPhone 13 in 2013 when you know an iPhone 13 wasn't out in 2013. Like, they drop iPhone like every year, but...
She basically just said, you dumb asking me that question. And I do want to say, so Tabiz TV sent a $5 super chat asking, if I was a judge reviewing Steele's motion, would I grant that motion? And if you mean the one that we read at the beginning of the stream, the motion to disqualify, the request was for a hearing. So as a judge, I'd absolutely grant that. As a person, as someone who just wants to keep looking, I hope that she grants that because I really want to see it argued orally. A lot of these motions that we've been looking at the last few weeks, since there hasn't really been a court session, it's all been written motion, written ruling. But I'd love to see some attorney sparring in the courtroom once again. And then Taybiz TV, are you covering what's currently going on over on your channel? Drop a comment letting me know, and you don't need to super chat it, but I'll look for it to come through the regular, what topics you guys are covering. That way I can let people in the chat know. And then Seven is becoming a member. Thank you so much. Guys, if you're a member, you get to choose a Mario Kart racer in the chat. I have dibs on Yoshi. Oh, and Sylvia, so you're in the court. I'm assuming you're in the court. You're always in the court. So you guys, we will, I'm sure, Sylvia, you'll probably go live like after you leave for the day, after the status hearing. So guys, if you aren't already subscribed to Infamous Sylvia, she's always in the courtroom. I don't know what time she'll be able to go live, but make sure you subscribe over at her channel. That way you can see it when she does go live. She also had a conversation, a Q&A with Max Shart on her channel yesterday. So check that out if you didn't see it already. And then Q, pushing positivity.
I thought it was out. Then you saying May the 13th. Then you saying May the 12th. Like, then you saying that somebody kicked my door. Then you saying I opened the door. Like, I don't know. Like, I don't know which one y'all working, but you working it.
Ms. Bennett, do you understand that I can't testify and that anything that goes on the record for this jury to consider, you have to say it?
Mr. Sharp? It's commentary, Christina. I'll sustain the objection. You can just rephrase, madam.
Do you understand that only what you say is evidence and not what I say?
I don't know.
Okay.
Like, holy moly, she's not a lawyer. She's not a legal expert. And you're asking her to kind of understand a legal conclusion. And what's the insinuation if you're asking somebody, hey, you have to be the one that says it. I can't be the one that says it, because Brian Steele, Keith Adams, Max Shart, they're all ready to jump down my throat, rightfully so, if I start testifying through my questions. So I need you to say it. Is that not the implication there? Is that not the nudge that love is giving there? Do you know that I can't say what I need you to say because you're the one that can give testimony? It's just so stupid. This was such an explosive period in and of itself. If you guys go back, I think this was the end of March. This whole, everything that stemmed from this witness, it was like a mini explosion compared to what we have now with the ex parte, but at the time it was huge. And she was just as annoying as ever. And then Taybiz TV is covering what's still going on with the YSL trial as well. If you're covering the status hearing, let me know, because I don't plan to keep streaming that, but I can redirect people somewhere.
So do you understand that I have to ask you questions in order to have you answer for the jury?
I guess so.
And when you said that I was manipulating the situation, what situation is it that you're talking about?
I answered it.
Would you answer it again, please, for the record?
I'd object and say asked and answered.
I need you to be clear for the record, please. Which situation?
I don't.
There you go, Weinstein.
Ms. Bennett, hold on 1 second. I'm going to overrule your objection. Madam, you can answer the question.
I don't know how to answer what she want me to answer. Like, I'm thinking that I'm answering it, but probably not good enough to her extent, because I don't know. When I say situation, I don't know, like, because 1 minute you on this person, then you on that person. So I don't even know which situation got nothing to do with this situation. I don't know.
All right.
You know what I'm saying? Like, you're confusing me.
All right, let's be a little simpler. Did you just tell the jury that you felt I was trying to manipulate the situation?
Yes.
And what was the situation that you were speaking of? You have to say it for the jury. What was the situation that you're speaking of that you felt I was trying to manipulate?
And that's what I'm saying. Like, I'm answering the same question you asking me over and again. Like,
Ms. Bennett, Do you?
I don't know, because you spoke to me like on a lot of situations. Like you was talking about Thug, then you started talking about my kid's dad, then you was telling me, asking about my mom, like, but I don't think all those things went together. Like, I don't think all of them mattered with each other.
Tell the
So
jury
I don't
what
understand.
Tell the jury what I talked to you about.
I thought I just did that.
What did I tell you, or what did I ask you about Thug?
You asked me, did he do a lot of things to me?
And
Like
what,
you asked me, did he break in my house? Did he get this? Did he do that? Like all the questions you just asked. Like I can't remember all the questions you just asked. You ask them over, I can answer you.
all right. And do you recall what your answer was?
Yes.
Okay. What was your answer to me when I first met you in the Wendy's parking lot?
Yeah, you asked me, did I recall this person, and did he do these things to me? And I told you no.
What did you tell me? What else did you tell me?
Then we started talking about other situations. You was telling me about situations you had, and I think I started talking to you about my mama, which that's something I just told you. We ain't gonna do that here though.
Okay. Did you tell me that you had blocked out large gaps of time?
Yeah.
Okay. Did I tell you that an officer had stated that?
Your Honor, I'm going to object to number one, testifying, and number two, hearsay.
Your Honor, I'd ask that the court allow me to form a foundation for the question that will follow.
I'll sustain the question at this point in time.
Okay.
If you want to lay some more foundation, that's fine.
Do you recall me talking to you about Thug, DK, and Thug's brother giving you back your items?
They gave him back.
I'm asking you a question. Do you recall me talking to you about that?
I don't remember you saying that.
Do you recall me talking to you about them calling and apologizing to you?
No, I don't remember you saying that.
You don't remember that? Mm-mm. What else, if anything, do you recall talking to me about the first time that we met? That you're comfortable talking about to the jury?
I repeat it because I just said it, but I repeat it again. When you talk to me about the situation with Thug. You asked me that I feel like he did any of those things, and I was like, no. And I know you did ask, was I scared of him? And I'm like, no, like I don't have reason to be scared of anybody. And then you talked a little bit about yourself, and then we talked a little bit about the situation again. Like I said, you about to keep making me repeat myself about my mom, and I said I don't want to talk about that, and that's what we talked about.
Is it your testimony that you said that Thug did not do these things, or that you did not recall the year?
No, I told you he didn't do those things.
Okay.
And you asked me, did it happen in that year? And I told you I don't remember a lot within that year.
Okay. Did I ask you where you lived in 2013?
I think you did.
Did you tell me you couldn't remember?
No, I told you where I lived at.
That's your recollection, that you told me where you lived. Is that what you're saying?
Mm-hmm.
Basis. I sustain the objection.
And do you recall what the inside of your apartment looked like in Trestle Tree on May 13, 2013?
Objection, relevance.
Overruled.
You may answer.
I'm not sure because I know we had remodel. So, but I think it was 2012. I'm not sure. I don't want to be wrong.
Do you recall what your address was?
Look at the deputies. Look at them.
Wrong.
Do you recall what your address was on May 13, 2013?
Mm-hmm.
What was it?
980 Confederate Avenue.
Was there a number or a letter?
Oh, D.
Just one moment, okay? That's all I have right now, okay?
I don't know what's on the screen now. Young Thug defense attorney calls out state prosecutor. I mean, maybe we can just keep watching that while we wait for Sylvia. I think you have to go through the YouTube Studio app if you're on your phone. But if you go to the YouTube Studio app and then go to your channel settings, there should be an area in there that is like community. And there's 3 tabs in there, and one of them allows channel redirects. And you'll want to set to, if you subscribe to my channel, I think you do, you can set to channels that you subscribe to can allow redirects to your channel. And that way, when you go live, we could send a trip. We can all go on a trip over to your channel. And then guys, Q, thank you for the sticker. And also you had some, how is this? She's leading questions. This is a mess. I think the defense a lot of the time in this trial has just let love go on because it looks stupid. You see the deputies laughing. And maybe there's a small chance that they might be laughing at the witness, but I would guess they're laughing at the interaction between Love and this witness. And how the witness is like, well, I don't want to be wrong. I don't know. I told you that already. No, I actually answered you. I didn't tell you I didn't know. I had to correct you about the iPhone 13 and when the iPhone 13 came out. I think the deputies are likely laughing at the interaction and not at the witness themselves. But I think that's why the defense attorneys just let Love keep going. Even though this stuff is objectionable, rather than object every time that Love asks an improper question, just let it go. But they do object when she injects testimony and, you know, they do object sometimes. And I also want to say, it's weird watching this. Is this a leading question? Shouldn't Love know better? Love just seems to do what she wants, ask questions the way that she wants to. She has no problem letting the witness know, hey, I can't testify. You have to testify. So I need you to say something. Like, just a mess all around. Just a mess all around. Yeah, I really think I agree with you, AJ Taylor. They let herself dig a hole. And then shout out again to Drea. Drea has been dropping the links to both Infamous Sylvia for when she goes live, she's in the courthouse, and then Taybiz TV, who's also covering, you know, a lot of the new stuff happening with the YSL trial. So thank you so much, Drea. You do hard work out here. And then Cavell O says, it's Friday, what we drinking? I do think Nick Starro is doing a panel stream today at 6 p.m. Eastern. I don't know what that time is for you guys. That's about 7.5 hours from now. So, and then let's see. Does anyone remember? It was early on, and I think it was one of the police officers. But Love asked them a question. I don't even know what their answer was. I don't know what the question was. But Love asked the question. She's expecting a certain answer. The police officer's like, no. And then Love goes, are you certain? Like, she pauses and asks if the witness is certain because they gave a no answer. A no is a pretty certain answer. It's not, I don't know, or, no. It was a no. It was not the answer she wanted. Oh my gosh, crazy. We can watch this one. I don't remember exactly what day this is. But we'll find out. Because we don't have that much time to pass until 11:30 Eastern.
Else?
Your ruling's done. You've already ruled. That's fine. We accept that. But I just want to address something that's further to the bench that I want the court to address.
Sure.
And I just need about 3 or 4 minutes. I've got to say this because I've been sitting there after our conversations. Let me just preface it by saying in any of our objections, whatever, you make a ruling. Sometimes we win, sometimes we lose, we move on. That's fine. If after your ruling, I've got a case that I want to bring to your attention, I say, Judge, reconsider your ruling based on this case, and you consider it, that's fine. If you don't want to consider it, that's fine too. But what I found objectionable, and I want the court to address with the state, is what happened at the bench earlier. There was an objection to the video, you made a ruling, we moved on. The state came back up and made representations to you. And they weren't representations based upon some new case law that they had found. There were representations, misrepresentations that were made directly to you, all of us standing there right there at the bench. She said something very, very fact specific in an attempt to get you to readdress the issue again. Madam Prosecutor said, I want you to listen to the 17-second video, because what you had based your ruling on was that the parties in the background couldn't be identified, right? And Madam Prosecutor said to you, and was not accurate, and I'm gonna be charitable and say that she was disingenuous. What she said was, these people in the background, the only thing that you hear are people saying, yeah, yeah. That's it. When Mr. Steele corrected her and said that's not true, she said, Mrs. Steele is not accurate. What Mrs. Steele just told you is not true. The only thing you can hear in the background is yeah, yeah. And actually, when she stepped up there, it was in an attempt to act as though she didn't know what your ruling previously was, because their attempt was to go ahead and play the video at that time, despite your previous ruling. My point is this. After you decided to reconsider, you want to hear the video yourself, you had a chance to hear it. You had a chance to hear what we had already heard, what we knew it said, what they knew it said. And there are at least 5 or 6 different things on that video audio that were in contradiction of what Madam Prosecutor said. On God, snitching bitches, I'ma tell a lie on God. That's what I'm talking about. No back and forth with you, bro. Fuck nigga. I'm not just saying that for emphasis. I'm saying that because what she said to you was inaccurate. At some point, Your Honor, I'm asking you to, we've had this conversation about candor with the court over the course of the past number of weeks.
3.3.
Yeah, we've had that conversation about it. And when we step up to you and we make a representation, it ought to be candid and it ought to be truthful. And what she said, and look, if she wins the motion, ultimately she wins. But you don't do it by standing there 3 feet from you in your face and lying to the court. And that's what she did. And she knew what she was doing, and it's not right. You heard Mr. Steele. Mr. Steele said, Your Honor, I am willing to surrender my bar card and have her surrender her bar card if what she is saying is true. He wasn't wrong. She wasn't wrong. She was not candid with the court. And at some point, you've got to say to the parties, if I'd done that, I would expect you to say, Mr. Adams, don't do that again. Don't step up to me and lie to try and get me to rule or overrule something I've already ruled on. Don't do it again. You ought to say that to them. We're not playing games in this courtroom. These are these people's lives at stake. And like I said, sometimes you win a motion, sometimes you lose. But you don't get the court to address something or readdress something like that. That's all. Say something to them is all I'm requesting.
All right, sir.
Please, just one time, be fair.
Your Honor, I would not have asked the court to listen to the 17-second video.
But what you did tell me, Ms. Love, wasn't the entirety of what was purportedly on states 112 Bravo. It did have other statements on it. It's different if you'd have told me, Judge, there are statements on there. Probably.
Guys, you hear Judge Glanville. Don't let him hold you in contempt. Hit the like button.
You listen for yourself. Not just yeah.
Your Honor, my recollection, and I'm going to speak candidly because it's been.
I would hope there'd be nothing less than candor.
And Your Honor, that's what I've been pushing for all along. There have been times, as the court is aware, that we have been at the bench and misrepresentations, bald misrepresentations have been made, and the court has seen my reaction to them. I am the one that's constantly saying I have a duty of candor to the court.
All of
When
you
Mr.
do. All of you do.
We do. And when Mr. Adams just read those series of things that he read, those half of what he said, I didn't catch. The part that I did catch and remember is the part I kept repeating just now, snitching bitches. And I didn't even recall that that part was there. But what I did know was that the relevant portion and the relevant speaker was Mr. Williams. And Your Honor, I'd ask, we can do this in chambers or wherever, but Your Honor, I believe that certain requests and comments to the court have risen to a level of being not true motions or requests based on legal analyses, but more leveled specifically on a personal level, which I've attempted to stay away from. Whatever one's reason for doing what they do, if it's to better advocate for their client, that is fine, they're entitled.
Well, you're not entitled to do everything in whatever position you're from, be it the state or be it the defendants, because you have a overall right of candor, responsibility of candor to the court.
I agree, Your Honor.
There are certain things you just cannot do anyways. Zealous advocacy is one thing, but it should never be confused for misstatements or for anything else that's not less than candid to the court. I think both sides, you all are fighting very diligently and valiantly about your respective sides. And as I said a couple of days ago, what the public sees is there's friction between the state, the defense, and the court. That is natural, and it is good for the system because it shows that we are not in collusion with one another. Justice is what it will be, and whatever this jury will decide. But what I am going to just advise everyone to kind of relook is what you tell each other, what you tell me, because there have been times where I have not received, I would consider what is accurate information. Let me just put it that way. Okay. And I know, and I'm not trying to attribute, dishonesty to any party, but I have to rely, all courts have to rely upon counsel for their representation. So if you can't remember what it is, just tell me that. It's just like your duty to, upon asked if there's any adverse position to this particular statute of law, you're required to tell me. I mean, I understand there's zealous advocacy, but I would also just remind everybody within the sound of my voice, professionalism really does matter to you all, and it matters to the court, and it matters to those that are watching this particular trial. Yes, there have been some times that these proceedings are acrimonious.
This is so interesting in
intense.
retrospect.
And the court has had to chastise both sides for things that have occurred. I don't have any personal issue. Remember what I told you. I would tell the jury this when I charge them. The court has no interest in this case. My sole responsibility is to see that it is tried fairly as to both sides. So, and I maintain that in terms of I respect everybody in here as advocates, but I do need to have you just relook what you're saying to each other and to the court, because it really does make a difference in terms of our presentation before this jury, and then ultimately the jury is going to make a decision. So
this is so funny because today we just have that motion from Brian Steele and Keith Adams saying, hey, we're requesting that the jury be read an instruction about how the judge is supposed to be fair, not biased, how the judge isn't supposed to express something that would lean against the defendant. A judge isn't supposed to express something that would nudge to the jury that they might think the defendants or any of the single individual defendants may be guilty. So they ask him for this, they motion for Judge Whitaker to include this jury instruction today, this filing that we read today. And here Judge Glanville, back, I don't know exactly when this was, end of March, maybe beginning of April, because Law and Crime we kept playing once it auto-played. But here he is, like, fair, we're supposed to be professional with each other, and the jury's meant to decide. But yet you've been so blatantly obvious in your lean towards the prosecution throughout this trial that now people have a rightful reason. They have a basis to request a jury instruction, letting the jury know to disregard any perception of bias from the tribunal, from the court. Like, that's just crazy. Like,
seasoned advocates, even the newest lawyers in here have crossed that particular bridge at this point in time, given the length of time that we've been in this courtroom. So I can just tell you from everybody's perspective, Ms. Love and everyone else, Mr. Adams and all of you in here, that you all have jobs you have to do. The court understands that. But please remember at the end of the day, this won't be the last case you try with one another, and won't be the last issue that you try. So
how funny would it be if this is actually the last case certain lawyers in this room try with each other?
But the court understands that you have a job to do. But understand that I have a job to do as well. I'm the referee. I have to determine what comes in and comes out in terms of my functions. So understand at the end of the day, we have that similar goal, but I understand you all have dissimilar objectives in terms of what the exigencies are in terms of your roles and responsibilities. But don't ever forget your duty of care to the court, your duty of professionalism as advocates, and the duty of civility. It still applies in criminal cases as well. These defendants are presumed to be innocent, and they are innocent, and that's what this jury will ultimately decide. But we'll have to get there, and we'll make it, and they'll make a decision. Okay.
And Your Honor, I'm certain the court means until proven otherwise, they are presumed innocent until
they're innocent right
otherwise.
now as we sit here. So and until I charge the jury accordingly and otherwise, and the evidence is presented to them, well, evidence first and then charge them. But as to how this case goes.
Thank you, Your Honor. And thank you for addressing also the concern that I have, because that is my main concern, the level of civility and the level of personal commentary level. That
always her
in my
problem
estimation, not
is her personal
necessary.
offense.
And I appreciate the
But that's
court addressing
everyone,
that.
everyone's can be accused of that at various times in this particular trial. I mean, I think that every issue that you have secrets, anything that's been raised at this point in time, anyone who's sitting in this courtroom is probably violated at some point in time or another. However, let's just try and do better in terms of that. But just like I told you with evidence and the other things that need to be brought forth, let's try and do better with that, because certainly, as I mentioned earlier, I don't want to have the jury sitting here for long periods of time.
Guys, this is why this trial has taken so long. This has been 13, and we had a little bit in the beginning of like defense arguments. But all this counter argument, it's taking 10 minutes for them to come up with a reason why they're not going to agree with the defense here. Or why, at the very least, they're going to turn it and make it an everybody, both sides type of issue. This is why this trial has taken so long.
When we take up other business, so we need to plan accordingly. But I think you all could probably, do a better job at least forecasting what is going to be tendered or submitted so that we can minimize delay. So, I mean, to the extent you all started to do that, it seems to be working a little bit better, but we'll see how it goes. All right? All right, so I have ruled upon 112 Bravo Bravo. What I'd like to do is how much do you have left of your witness here?
I wanted to play that video, Your Honor.
All right.
So how
We'll have to
much?
see what they autoplay next if you guys want to keep going.
Okay, so
I said something
how
about a
much
witness
more do you-
interview.
Yeah, just estimate, okay? Because I'm gonna double whatever you tell me. So, how long do you think you'll have more of Sergeant Gaither?
All right. So we're gonna have some fiery steel, fiery Max Sharp moments, I think, coming up on this autoplay. I'm gonna leave the banner the same. It probably will apply, so we'll leave that. But I want to thank Annabelle. Thank you for your help, and also Drea for your help helping Miss Sylvia set up the redirect. She has enabled it. I see it, and I have switched this video to redirect into the status hearing at 11:30, whenever we end the stream. I also saw Cadillac Law is going to go live. Let me write this. And Cadillac Law, I don't know well. I've caught her content a few times, and she just seems so sweet. She's really knowledgeable. She's actually a lawyer. So if you haven't checked Cadillac Law out, I do want to drop her link. I just dropped her link in the chat here too. So she just seems really sweet, and I've never shouted out her coverage before. And then Nikki Turner, thanks for becoming a member. Classy Beats at the $5 says, I've learned a lot watching your channel, Kat. Keep up the great work. That's right. I'm here. I appreciate you. And then Candace, your comment earlier, I'm surprised, but I don't think I've seen someone call him Judge Uranus before. Thank you for your super chat. And then Aaliyah says, it is a beautiful Friday. Happy Friday, everybody. So, yeah, I really don't think... And yeah, Cadillac Law, Cadillac and Sylvia are both great. And guys, it is crazy to feel like, I feel like I look at this case so much, and then there's still people covering this case that I come across and I've never heard or seen of before. And I'm like, who is this person? And they're doing well. Their videos have numbers, and they just never got into my algorithm, my YouTube For You page. But Cadillac Law is someone I came across like this week, and love so far. So shout out to Cadillac Law. She's doing a great job out there. And then, so how this works is I have a redirect set up that when I end this stream, it'll carry you guys over automatically, unless you guys don't want to Miss Sylvia's live stream. But everybody else, we are like dropping links. That way you guys have some options. I know some other people, I don't see like a stream for lead attorney. Any other creators? I'll look. We'll play this video and I'll look in the meantime.
This is the second time that this honorable court in front of the jury has addressed me inappropriately and wrongly. Second time. The first time I gave the state discovery of a song from a Super Bowl weeks before. There was an objection. You assumed that I didn't give it to the state. I didn't want to embarrass the court. So you were yelling at me and saying, do you understand me? Do you understand me? And instead of saying, do you understand that you're wrong? I sat here and I said, yes, Your Honor. That was to protect the integrity of this courtroom and the court. Now you say in front of the jury how unprepared I am. I am not unprepared for anything.
Okay,
I have
Mr.
no.
Steele,
I need to make
Mr.
a
Steele,
record. Your Honor,
Mr. Steele, wait a second.
Record.
When you keep delaying, okay, and that's what's happening to the court. You keep delaying and elongating.
You hear his tone?
And pushing out these particular our ability to present a seamless case in front of the jury. That's my purview as a judge. And I've asked you a number of times, you and your colleagues on both sides, to go ahead and listen to whatever it is you need to do, prepare me as needed. Now, I asked you those two particular questions because if they turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection. And I was trying to solicit from you whether or not we could just go ahead and just hear it. So you can imagine my frustration because all these little delays just elongate out the whole our presentation in front of the jury. That's for your benefit, not for mine, Your Honor. So that's why I've told you all at various times during this particular case. It's not because I want to embarrass you, Mr. Steele. It's just that I'm trying to kind of keep this thing presented in a way that the jury can listen to it.
And the court is wrong. What happened was, let me finish, and I'm making this for the record. What happened is, and I don't get embarrassed by you, but I don't want to embarrass you. I made an objection that some of these jail calls have a third party who will not testify. I objected to hearsay. The state said it explains the effect
Okay,
let me finish.
Which call? Which call?
These calls, as you...
Okay, well then why aren't we taking them up beforehand?
The state just said, just now, these are the 3 additional calls that they want to introduce.
All right, well, then here's your response. I'm going to give you an acceptable response.
Well, I'm going to make my motion.
Huh?
I need to make my motion.
Judge, there's more to this than we need to listen to these calls.
Right.
Then I would have no, you didn't say that though. So I wouldn't have had that opportunity. But that's why I keep telling you this, okay? I mean, like I told you, forewarned judge, a happy judge. All right, so had you just told me up front, Judge, we have not had the opportunity to listen to all of those calls. We've only been able to listen to 2. I want to listen to the other ones. And
I've listened to the calls. I know, I don't know what the third one they're trying to do.
Okay, well,
listen, let me just finish. So you presuppose I don't know what the calls are. Well, I don't know what the third call is because Ms. Hylton, who's professional, said, I'll take a break and I'll let you know what it is. But the other 2 calls are the baseball game and at the chicken, they're discussing chicken wings. Or chicken. I understand those calls. There's issues in those calls that you need to address. But I politely make an objection and say, Your Honor, based upon what you told me, which is what you told me, we'll take it up later. I wanted to raise it. You tell in front of the jury how unprepared I am. And let me tell you something. I am not unprepared. I don't appreciate the court telling me that. And you don't, and I asked you, tell the jurors that you were wrong when you admonished me last time. You said you wouldn't do that. This is the second time. And you know what it does to me? I don't care. I'm hurt because you're a court, but I really don't care. But what does it do to Mr. Williams?
Mr. Steele, I'm not trying to personally insult you or hurt your feelings, okay? You are a grown professional advocate. I'm a grown professional jurist. And people say things to me that border on the lines of I could take action or not. You have certainly said some of those things to me during the trial of this case. I have let them go. So, sir, that's just the trial. That's just the trial of the case, okay?
No, but that man's life is here.
And you know you're doing a fine job in representing him. Well, but you know what? That's just the way we are right now. But the crux of the issue is, Mr. Steele, and the representatives from the state and everybody else. What happens right now is I have to take a break in order to vet all of these issues, which I'm required to do, Mr. Steele. And that's what is kind of disappointing to me because I have given you all this administrative time, all these breaks to go ahead and do this, and this is what delays the presentation of this case in front of the jury.
You know, if I would have done what the state did, and I'm not poking anything at Ms. Hylton, you would have said to me, why didn't you share those calls with him before? What, you were out all day today. We didn't start court till 1 o'clock. I would have shared them.
I know you would have.
But the state didn't. I'm not poking fun because I can deal with it. But when the court then steps in.
But here's the problem. I have a problem with it because at the end of the day, I got to listen to a 15-minute call.
You don't have to listen to anything.
But
you have to make a ruling.
Yes,
on
but I have to listen to it in order to make the ruling on those. And even if you said you've listened to the chicken call and the baseball call, and if you say there's other issues that come into play, it's better for us to take those things up before I ask for that jury. And I could have done that this morning. I could have done that at another point in time. So, I mean,
I raised this issue to you, and I don't remember the date, but it was days ago. I raised it, and the court said, all right, understood, and we'll take that issue up. when it comes. Now, what am I supposed to do?
Okay.
Sit there and say no objection?
No,
That's
no,
exactly
no, no,
right.
not at all, not
I
at all.
said, Judge, it's an issue
Not
we
at
need
all.
to take up.
Not at all.
And in addition to that, today alone, and this happens, today alone, the state introduced 2 exhibits. I've never been given them before, ever. You know what I did? No problem. No problem. Because I think that's professional. One was a Google map. It needs to be clarified for the record that it was not done on September 11, 2013. And then a map with little dots with 0.4 miles. I've never seen before. But I didn't do anything, Your Honor. I want to move the case. But when the court, it gives me no pleasure in saying this. I believe that this honorable court is biased against Mr. Williams and or his counsel. And I ask you to consider recusing yourself, or don't do this again to me. This is inappropriate to me. I respect you, but what am I supposed to do? Sit there while you do this? I didn't do anything wrong. I did exactly what you teach me to do and the courts teach me to do.
All right.
But instead, no, I got to finish this. Then I get told to this court says by Prosecutor Love that I'm not being candid with the court and I'm misrepresenting because Mr. Bean never went to the hospital at Grady on September 11, 2013, and Miss Love has a document on the desk to prove it. I sat right in front of Your Honor at the table, at the bench, and I said, I'd be careful what you say. That's not accurate. Ms. Love looked down on me and she said, it is accurate. You said, we'll take a break, figure it out. After the break, you didn't even bat an eye. Ms. Love said, yeah, I was totally wrong. Mr. Steele's right. He was taken to Grady.
Look at her head. Look at her shaking her head.
Called another member of the bar disingenuous, not truthful, no candor, and misrepresenting. You would have had me yelling in front of a jury. You did nothing. You didn't even ask Ms. Love to apologize. I don't want her apology. I don't care about Ms. Love. But I care about the court. And now if you can walk in someone else's shoes just for a minute and see what you're doing to Mr. Williams, because it's hurtful. I'm not the one wasting time. I'm here every day ready to go. I am not wasting the time. I make a motion to ask you to please recuse yourself. I know it has to be in writing within 5 days. If you want me to do that, I'll do it. And it has to go to another judge. But this is what's going on, Your Honor, whether you see it or not. You're yelling at me in front of a jury for nothing. And then you won't apologize. And I did nothing wrong ever on these occasions or others.
I'm going to go ahead and address your motion at this point in time. I'm going to deny your motion at this point in time. And also just direct you that I have the responsibility to control the proceedings in this particular circumstance. Sometimes things get kind of heated. And that's kind of that's the crucible and
now it's going to be both sides
of any particular case. I am not in any way intimating or insinuating that you are not professional, you are not prepared. But the things that I am bringing up to both of you, and I have fussed at both sides for this particular issue of not being prepared in the sense of, and the only reason it affects the trial of the case is it makes the proceedings a lot longer than they should be, because all these things could be taken up. And sometimes if we've got to parse out all these things, as you can see right now, it takes time. And that's what I'm kind of concerned about, having been a jurist for a long time. So I understand that you're a zealous advocate. You in no way offend me by raising any type of motion. I think you're doing I think that you and the others here are representing your clients well, but sir, I have to be able to control these proceedings. And you at times in these proceedings have not listened to what the courts told you, and I certainly could have explored other options. I didn't. So I'll tell you that much for what it's worth.
You allowed a member of the bar yesterday ask a witness who constantly is committing, respectfully, potentially perjury. Did Mr. Steele shut off and turn on the recording? I never did that. I wouldn't do that, and I didn't do that.
Okay, and but sir,
I would have said that question.
What's so dirty about that implication too, that Brian Steele turned off a recording to leave certain things out of the recording. What's so dirty about that is that's what that's what investigators will do. That's honestly what people in the DA's office will do while they're meeting with witnesses. They just won't record it. So that way there's there's no record of it. So when you see a judge give an implication that, it must be bad if something wasn't recorded. Well, then is it not problematic when Hylton is meeting with Woody for multiple days leading up to this, him pleading the fifth, and she doesn't record any of that? Would the implication not also stick to that situation, that scenario? Why don't you record these meetings that you're having with Kenneth Copeland one-on-one? But it's okay. It's okay.
About another member of the bar, prosecution, you would have come over the bench and said, how dare you? I sat there and I said, outrageous. You deny the motion. I think 3 other people made motions to strike or to object. You denied it. Judge, I'm just telling you the appearance, if not the reality, is not good here. I'm being...
What, to who?
To Mr. Williams.
Okay, but
maybe to the others. Maybe
you're his advocate, okay? And that separate issue of whether or not you did what you did, the state accused you of that. They have the right to at least inquire about whether or not that happened.
Oh, they have the right to inquire. But if I inquire, you're going to ask me, who told you? Who told you?
And whether or not it happened or not, I'm not making any comment on it, but it goes to bias, it goes to motive to misrepresent.
So that never happened. No good
okay,
faith.
but I'm not commenting on that. That's for the jury. That's for the jury to decide.
I asked a question about a missing recording that wasn't given of a statement made by Mr. Bean. And know what you told me?
And I keep telling you.
Know what you told me? You said, does the state have it? They said no. You said nothing I can do. I tried to cross on it. You sustained an objection.
Because it doesn't exist at this point in time. Now, if it exists at some point, I told you I'd say it. 1, I tell you, I apologize to you. And then 2, I'll take corrective action against the party or the entity that...
So, shout out to Present Not Perfect. That's a great name. Have I seen the videos with Love and Glanville giving hand signs? At this point, I don't even know anymore. It's just, there's a lot of mess. I know I've seen Hylton seeming to, play at her ear right as Glanville's playing with his ear, and they're both looking in each other's direction. But is Love also caught doing the same thing? Because it really wouldn't surprise me. And I don't necessarily look at one instance of someone touching their ear when someone else happens to do it as being nefarious or intentional. Because, someone yawns, you yawn too. Someone does this to their mouth, you think, oh, do I have something? And I do the same motion. But if there's a pattern of it, if there's all this footage, and it's multiple people doing it, and Love has also accused the defense of making motions, and Love seems like the type of person to project, it wouldn't surprise me if Love was also doing some signaling in the courtroom. And then Classy Beats, thank you for the $10 super chat, says, I want a public apology. So Brian Steele's like, I don't even want Love's apology. But Classy Beats says, I want a public apology from Judge Glanville to the Lawyer of the Year, the Honorable YSL Brian Steele. Well, if Judge Granville is still in the chat, maybe we can get an apology. Thank you so much.
I failed to give you that particular statement.
But the point is, everyone knows he spoke to the detective
But
beforehand.
we don't. That's the whole thing about it. You believe it. You honestly believe it. And that's true.
On September 17th. 2013, I'm recording. Mr. Bean tells that to Detective Quinn. How is that far-fetched? Why would he ever say that? I lied to the other detective. Why would he ever say that? I mean, logic has to come into this courtroom at times. But you stop me from doing it, but you allow another lawyer make up that I'm stopping and starting a recording. And he says, well, I don't recall. I don't remember anything.
Here's the thing. That's why probably Miss Love asked me to put it under seal for the time being. But I mean, I'm not saying anything. But if true, that's a pretty serious accusation.
If true, I'll die right now. How about that, Judge Glanville?
Your Honor, I object to this.
I don't care about her objection. I'm speaking with the
Your Honor,
court.
I object, and
I'm
I'd like to
speaking
level
with
an
the court.
objection.
Okay.
I'm
all right.
speaking
Let
with
him
the
finish,
court.
and then you can state your.
My point is, if you don't see what's going on, it's because you're not viewing it out of the lens
But
of a juror.
Mr. Steele, I can't do that. I have to be the referee. So the jury decides those particular issues of believability and credibility. Now, I'm not getting into the throes of war between you and the state. That's your business, and that
I
is
have
certainly
nothing to do with a third war.
No, but I mean, it's your ability as an advocate. I told you before, that's your ability as an advocate. All right?
What I'm saying is, you said in front of this jury, I was unprofessional. I am not unprofessional. You were wrong.
I think at that particular point in time, given the totality of what happened, that's what the court's assessment was. Sir, I am.
But it was wrong.
It's a snippet in time. Mr. Steele, you're a very good attorney, but I'm a professional jurist, and you may not like some of the rulings that I make, and you may not like the way that the trial is going at a particular point in time. That's for all advocates. Ms. Love and her colleagues, I've told them the same thing. But I think that, my job as the referee is to give you a fair trial. And that's what I'm going to do.
Well, I hope that's true. But you just told the jury I'm unprepared. And I am prepared. I don't understand why you would say that.
Both of you, and I'll level this against the state. Both of you, that's being unprepared, because that I have to then listen to this to rule on it.
I understand, but I'm the only one that the jurors here, the court, take ire with. Ever. Without an apology, without.
Oh, I think I've taken Ms. Love and Ms. Hylton and her colleagues to task many times.
No, I've heard you yell at them.
I've taken them to task as well.
I've heard you say to her, stop interrupting me, answer my
that's
question.
that's taking them to task.
The jurors never heard that. Ever. So I ask for a continuing recusal motion. And I know it's not in writing, but I assume that you're ruling on it right now. That's what you're saying.
Well, when you got to put it in writing, but I mean, I'll rule on it at this point in time. I'm going to deny the motion, but you need to put it in writing if that's what you wish to do, and I'll appropriately.
I'm also asking for a mistrial based upon your statements. I think I made that clear, but I'm asking for a mistrial.
Okay, now, Ms. Love.
I don't think it's a fair forum for Mr. Williams.
Okay.
And I don't want to ask for a mistrial, but I have no choice when the court is saying what it said, and I'm not going to repeat it in front of a jury. That's hurtful. And I'm not saying me. I mean, regardless of what I think of it, it's hurtful to Mr. Williams getting a fair trial.
All right, Mr. Steele, in terms of what I've told you all already, we're still going through the, I've told you all, both sides have told you. So this just delays the trial. I mean, where I've got to rule upon other things.
Oh no, a delay.
Motion,
Another
I made
one.
it, and I raised it, and you said we'll get to it.
Yeah, but it's timing. I mean, did you raise it when we first got in here this afternoon? Did you raise it yesterday? Did you raise it kind of so I could kind of take it at that point in time? None of you did.
If I would have been told that there were going to be 3 additional jail calls, I could have raised it. The 2 others are already in. I didn't object.
All right.
So we've got like 20 more minutes until the status hearing's live. So we could just autoplay one more. How long is this? This is about 27. We'll get through most of it. But this is crazy to watch all of this now in retrospect and watch these instances where Love gets mad because the defense objects to anything at all. Love is constantly bothered by personal attacks. But when Brian Steele is called unprofessional in front of his own client, and really in front of anyone watching who could hire him in the future, unprepared, just deal with it. Just deal with it. It's fine. And then obviously Glanville, oh, you're delaying this. This is a problem. It's your fault. Well, the state didn't tell us this until last night. No, it's still your fault. It's still your fault. And yeah, we'll do this at 1.25. That's a good idea.
Okay, Mr. Steele, would you take the point?
And then shout out to It Is Ramon. You say, I do believe that the judge wanted the case to move along faster, and that led to bias. Imagine if he just supports whoever's presenting. Yeah, and that could be it too. I think they expected that with how long jury selection took, they probably thought that by the end of 2023, they could have been halfway through at least the state's case in chief. And yet here we are, 100 days in, well into 2024, and we're not even halfway through their witnesses. So that's possible. I definitely think that that's possible. But then again, if you paid attention to the ACLU and Barred Business they filed a petition for a writ of mandamus to the Supreme Court of Georgia asking for them to order Fani Willis to move it along with these people that are sitting in jail without any indictment for longer than 90 days. And they included a transcript back from September 2023 where Judge Glanville's like, well, now that I'm aware that there's a court calendar backlog, I can do something to fix it. We can start doing Saturdays in court. We can start staying later on some evenings. Now I can remedy this. Because as the chief judge of Superior Court, he's in charge of the administration, the calendar management. And that was September 2023, and Barred Business and ACLU brought their lawsuit forward, I think, in April of 2024. So clearly, if no one can assume as much, Glanville didn't do anything to speed up the calendar and get these indictments, people that are sitting without indictments, their bond hearings. So I'm not really sure he's just effective at what he's supposed to do, whether he wants to or not.
Podium, please, sir. All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, I'm just.
But in order, you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raise it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte.
Watch their body language, the ladies.
It's just like when you asked me for an ex parte conversation.
I've never asked this.
Funny how you catch something new every time, or maybe I've caught it, but it's aggravating me again. But because the state asked me to. That's not really how the Judicial Code of Conduct outlines how ex parte meetings should be handled. Your reason for having an ex parte meeting shouldn't just be because someone asks.
A court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is, how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, or you're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not something.
No recording yet that we know of.
I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt And you can think about it. And 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an
may be
idea how
wrong.
you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not
Sir,
going to breach that
I don't want to hold you in contempt, but this is that serious.
Judge,
You
I don't wanna
cannot
raise it.
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information and belief,
From
that
whom?
part of it.
From whom?
Well, I'd like to get the substance first, and then we can
Okay,
talk.
well then you'll be in custody until then, because because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
But you're assuming something because I told you already.
well then, other than
Answer
if
that,
you were
and
if you were
the
sitting,
attorney
unless you were sitting in there with a recorder or Miss Love or Miss Hylton. Or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript. There's only one other person that's left.
Well, Your Honor,
And if that person gave you that information or shared that information with you, she probably violated privilege.
well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have
Well,
been.
it's because she has a client she's supposed to represent.
Who are you talking
But anyways, I'm not going to have.
But I got
I'm
this
not gonna have any
information.
further- I'm not going to have any further conversation
Well-
with you about this. I want to know. The question still remains. I want to know who gave you the information.
I'd like to know what information happened outside our presence. That's
All right.
really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your. I'm going to deny your
Coming.
motion. I'm going to deny your motion.
I
for
understand that you
mistrial.
spoke with a
And when-
witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is
you-
appropriate.
And you influenced the witness based on information and belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing
Okay.
happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue?
Look at
that
her
was
on her
outside of
phone.
presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
Why
that's for
did we
another
exclude
day.
in the first place? I didn't know about this. So
That's
I raised
for
it
another
before
day.
the court.
So-
I raised it as soon as we found out about it.
Well-
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele,
private.
that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been
right.
sworn. You know that I'm not telling you. I'm just saying if you read the case, I'm assuming you read it. That's what it says, and you did it.
Does the
Supposedly.
state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is
Thank
why
you.
did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind
And
anything.
you can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because
what
unless
I
you're
got-
sitting there. Unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
I'll
entitled to the-
that's
But that- isn't that the issue?
that needs to be told. But,
But,
do you have
right
anything
now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
And I want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right under
Just
the Georgia
stop.
Constitution.
Just stop at this point in time, because
Article 1, Section
because
1, paragraph
you already said that. You've already said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, madam, Ms. Love.
She was just itching to get up and argue. Oh my gosh. I've watched this so many times, you guys, but it is interesting. We're about to get a status hearing. That is, well, technically, they continued court after this. They had Kenneth Copeland testify. They looked through these videos, this interview footage. So they still had court after this, but really they probably should have stopped around this time period and waited to see what was going to go on with this contempt issue. But they didn't. But really, besides that, we're kind of getting our first pickup today with the status hearing. And shout out again, thank you so much again to Drea. She is dropping the links to all the different streams that are streaming this. This will redirect to infamous Sylvia, who is streaming live from the courtroom. She's got her laptop, her camera in there to stream for us. But we're dropping links to other creators. That way you guys have a choice.
And Your Honor, excuse me, and I know I said this previously.
Yes, sir.
But we are not accepting any proffer
Oh,
from
gosh,
Ms. Lowe.
okay, excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate, what he calls fact, and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition. He asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned.
Do you think she reached out to the state bar and asked for the appropriate remedy for what happened when she and Hylton and Judge Glenville had this ex parte meeting? Do you think she did that?
We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Another moment.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right.
So even on 1.25, I don't think we're going to make it. We've got a couple more minutes. But this made me laugh out loud. It is Ramon says, imagine being on the jury and going out on Monday night to blow off some steam. And the DJ goes, Glanville recused Free Thug. And does the little horn sound effect, the trumpet sound effect. That's too funny. I can totally picture it. Oh my gosh. I wanted to see, does this part include the clip where... Let's see. Let's jump to this, because I do want to see the part where, if we can. Is this the clip where
I believe it's appropriate here.
Love wants Weaver to not
All right.
record
Motion
what's
for
going
mistrial
on?
denied. Ms. D. Williams? All right. Thank you, madam.
Go to Adam's
Motion's denied.
bed.
Mr. Gardner? Continue. I'm not called
Do
nothing.
you mean this part, Drea?
I'm not going to participate in trial without dealing with.
You don't have that luxury at this point in time, sir. You don't. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't.
Without the court addressing the issue, we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now.
I will not.
Say again?
Respectfully, I will not. I cannot.
Sir, you have, well, you're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time. Sir, yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly. Sir, I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning that.
If there is any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No, it's not, sir.
All right, you guys, the status hearing has started. So when I end the stream, it's going to redirect you to Infamous Sylvia, who is streaming. She's broadcasting live from inside the courtroom. We've dropped links throughout to different creators that are streaming. Dear Woke Christian, Lead Attorney, Tabiz TV, Cadillac Law. I'm sure many others are going live, but I don't want you guys to miss anything if you're watching that. So I'm going to end. We'll redirect. Thank you so much for your commentary. And I do want to highlight here, Matthew here was saying, Love was saying that the purpose of this ex parte meeting was to make sure the defense didn't find out what they were talking about. So all of this is crazy. Let's end this. We'll redirect. Thank you so much. And thank you, Drea, as always, for being such a great mod and sharing all those links to support the other channels. See you guys in the chat somewhere and maybe later on a live.